surprised by the way we looked. The years had changed us too. We smiled and both embraced like old friends often do.
Hello again. Welcome to another episode of Gung Ho. It's July 12, 2021. This is another show in that series that I started, Law and Disorder, along with War is a Racket. We're going to talk again today about the Cuthbert case. I told you about that case on my last show. It started in this town. William Cuthbert was arrested, I think, on January 13th, 2014. And the main charge was disorderly conduct. After the arrest, they really roughed him up to the point where they threw him on the ground, prone, handcuffed to the rear, got on top of him. I think you know that scenario from the Floyd case. Big cop got on the back of him. Anyhow, William is just a local guy, a builder, and they did their best to get him to take a plea. He wouldn't take a plea. In fact, he fired a lawyer that was a very good lawyer, and he came over to me. He said, I want to go to trial, I'm innocent. So he went to trial. Before he went to trial, he was zealously prosecuted. And I kept telling Judge Tukolsky that there's no crime here. There's no criminal offense charged in the disorderly information. So we had some dialogue, and this is what the judge said. I mean, it's incredible. And I lost my glasses. All right, well, hold on. You got them?
Yeah.
How's that?
There you go.
Prop. All right. I was asking the judge, so what is the offense? And this is what he said, Judge Tukolsky. Yelling and cursing in a loud voice where other people were there to hear him. So he went to trial for cursing at a police officer in his face. That's where he went to trial. And guess what? He was convicted. And he told the judge at the time that he was going to appeal. He appealed. So I looked around for a good appellate lawyer, and of course, I went to my friend Atwell, and he took over the case. And he did a terrific job. And the case was reversed on appeal, but I'll let him tell you, the gist of the case.
All right, Joe.
Talk to me.
You are relentless. You're one of the most relentless lawyers I've ever met. Thanks for having me here, and I never wanted to do it, but here I am. And what happened that day when you came over is I still didn't want to do the case because you're a friend of mine, and if we didn't win, I was a little worried about that because anytime you take a case from friends and you take their money, and the result doesn't turn the way you want it to, maybe the friendship gets bruised a little bit, and I didn't want that to happen. So I was a little reluctant to even take the case, and then when I saw it, I decided, well, I'm going to do it because there's no way you can lose this thing. And it was just so blatantly obvious to me and to any lawyer that a crime had not been committed.
Not even an offense.
Not an offense had been committed. And the law says that you can stand toe-to-toe with a police officer 1 inch from his nose and scream any obscenity you want, in as loud a voice as you want, and that's not a crime, that's not an offense, as long as it's not affecting the general public in some way, that there's no public dimension is the phrase that used. And, well, we read the complaint, we read the story, we read the police officer's reports, and that's all that happened. I mean, you have a guy with a foul mouth.
It wasn't even that. That's what they said.
Well, who knows what happened? There were only 2 people there, so who knows? It was between a police officer and a guy that just got into a fender bender in the middle of an icy road in February, in the middle of over by the golf course where there was no one around.
And you know that issue that you won on, we raised that.
I know. You did it, the first lawyer that was hired recognized it immediately. He made a motion, lost. You took over the case. You made the motion orally and lost. Then the trial happens, and you made 2 trial motions. After the people rested their case, you made what's called the procedural law 290. You made the motion saying, well, there's no, this case is over. We don't have to present a case because they never presented a case that outlines that an offense happened in the first place. Denied. So then you had to go to the rest of the trial. You went through the rest of the trial, and then the jury convicts this guy because maybe he wasn't not the most likable guy in the world.
Well, they gave the cops the benefit of...
Well, whatever the reason was, they got it wrong too. And you made the motion again, same one. It's essentially the same motion made in different time frames during the trial. So when you made it at the end, it's essentially the same argument, that you can't, it doesn't constitute the offense in the first place. And if there's no underlying offense, it's not resisting arrest because there was no legitimate crime in the first place. So you can't resist arrest for a crime that never was committed in the first place. It's pretty easy stuff.
They acquitted him of the harassment,
Which that makes no sense. And you pointed that out as well. So, you know, when I saw that all these things had happened, I said, oh, okay, no, I just got to write it. And it's just a matter of writing it, and I was almost positive an appellate court would recognize what you recognized and I recognized and the previous lawyer recognized, and that we tried to get across 5 different times. And of course, you know, once it got to an objective appellate court somewhere in Brooklyn that doesn't really know anybody or care about anything that goes on out in East Hampton, it was reversed. And I think it was a very easy, an easy one for them too. Go ahead.
It was reversed and dismissed, but explain exactly what the appellate term did.
All right. First of all, when I argued it on appeal, I made essentially 3 separate arguments. The first is the complaint itself, which outlines what's supposed to be the offense, never said that what this guy did somehow affected the public, that caused a public dimension. It was solely between the police officer and him.
I want you to actually read the words that you...
All right, what he said is not, it would make, okay. Well, first it talks about the statute, and then it says, in that, the defendant did wrongfully state obscenities in public, he said it in public, but there was no public people there. In public, after being requested by the police officer to remove his vehicle from the intersection after being involved in a reportable motor vehicle accident. Defendant was standing within inches of police officer Trotta while screaming in a loud voice in sum and substance, fuck you, you fucking pig. I'm not listening to you, you're an asshole. Get another officer here, you fucking asshole. All right, not a nice thing to say to a cop, all right? And so,
remember this, he didn't say that he didn't curse until he was handcuffed to the rear.
well, yeah, that's
The other thing
that
is
seems to be a detail.
He had already moved his van. He already complied with the officer's request.
Right.
All right, go ahead.
And yet there was only one other guy. The only other person that was there was
A nosy body.
yeah, just a guy who was at the stop sign. I think it was a stop sign.
He left and came back.
And it was a guy who was driving a delivery truck.
A big diesel,
And he looked at it for about 5 minutes, got bored, and drove away.
and then he came back.
And then he came back just to, because he was curious to see what was going on. By then, Cuthbert was already handcuffed and being thrown into the car. So that guy doesn't seem too annoyed by what had just happened. In fact, he was kind of intrigued, and he just wanted to go watch somebody get arrested. So this is the general public that was offended by this activity, or the tirade that he went off on. Go ahead.
Again, you get a reversal, and the resisting arrest is dismissed, and the harassment has already been acquitted on, which was, I don't know how that came that way, but explain exactly what did the appellate court do, and what was the result?
All right, they never even got to the fact that it went to trial didn't matter, because they never even bothered to go that far. what they said was, there were three separate arguments here. One is that, first of all, it would never, the complaint, the information that it's called, never stated a crime to begin with, all right? Now, if the law says that what disorderly conduct is must in some way affect the public dimension, it must affect the public in some way. The complaint itself never even says that.
You know something, during
that
the
nobody-
cross-examination, the officer admitted there was no
Right.
public dimension.
We have that in there too, and you even, on one of the questions you asked, because you were the trial lawyer, and you knew this, and the first question you asked was, well, did this cause a public nuisance? Was anyone offended? Was there any people around that were offended by this language and this behavior? And the officer himself said, no, not that I know of. So you stood up and said, well, then I make my motion to have this whole thing dismissed for failure to state a prima facie case, which means the elements of the offense were never proven because the guy who made the arrest admits that it never happened. So this wasn't a tough one to, it doesn't make a whole lot of sense why it ever went to trial in the first place. So the appellate court said, yeah, and then you had a trial, and then we went through the whole thing with what happened on the trial and all the motions you made during the trial, and that the jury found him guilty of it anyway. The appellate court never even bothered to go that far because they said, look, the first argument alone was enough. It never should have gone to trial. It should have been dismissed on the first week, the very first
But
thing.
what did they fail to go on to? You had another argument that,
That's what I'm saying.
yeah.
So then the substance of the case itself, then you had this whole trial, this long drawn-out trial with a jury that lasted, I don't know how long, 2 weeks or something? And so we put that argument in just in case, just in case they didn't go for the first argument, in case they didn't say, you know what, the information's good enough, the complaint was good enough, it's not facially sufficient, it's not factually insufficient. I was worried that they might say that. I really wasn't, but I thought, just to be safe, we better put the other argument in.
And the other argument is what, or was what?
All right, the other argument is, look, the trial did happen. The people presented their case, the testimony was this, the evidence was this, and even if you're giving everything that's true, even if all these things are absolutely true, with no defense at all, it's still not an offense. It's still not a crime. It doesn't, what this guy just testified to, what the people's evidence was, is not enough to fulfill the elements of a crime, of an offense.
So what happened?
So the trial went on, and you recognized that at trial. And anyway, it went on. So the argument was, considering all the evidence that was presented, that never should have been presented in the first place, because you never had to go that far. Even if you were to consider all those things, and consider all those things as absolutely true and uncontroverted and undefended against, even if you were to consider all of that, you still don't have anything.
The prosecution has not proved any criminal offense or crime beyond a reasonable doubt because there was none.
Well, they never had to go beyond a reasonable doubt. That's the next part, because they never alleged it in the first place. You never had to have a reasonable doubt. That's what the jury does later on. But before it ever got to a jury, you made the motion after the people rested. That's the first trial motion that's made. And you knew enough to make it. And they said, before I even put my guy on the stand, before I even present one shred of evidence, this thing should not go any further because nothing happened.
What you're saying is the appellate court didn't weigh the evidence.
They didn't bother to go that far. The appellate court dismissed it before they said in their decision that because the complaint itself was facially insufficient, because the complaint itself didn't allege a crime. The complaint, before he even said one word, the complaint itself is that.
Discon.
And then it says, he said these horrible things to a police officer within inches of his mouth, within inches of him. He said these terrible, vile, he went into this tirade. There's no sentence underneath it said end.
I want everybody to realize this. I mean, maybe people don't cursing at a police officer is not an offense or a crime in America. You get that? Cursing, even if there were people around, cursing at an officer is not a crime. And that's what he got arrested for, and that's what he was prosecuted for, and that's what he was found guilty for, cursing at a police officer, and there's no such crime or offense.
Right.
All right.
If there had been, and there are other cases we talk about that you know, a legitimate crime, offense does happen. For example, there are cases where a couple was getting in a very obscene argument in a hotel, right? And the people are, it's a hotel, people are trying to sleep, they can't sleep, they're hearing this loud argument, and so they call the cops.
Yeah.
And because it was offending the people that were staying in this hotel. So they call the cops. The cops show up, and the people are standing around because they can't sleep. They're, you know, they're in their bathrobes watching this. It was a married couple, for example.
Gas station.
And then there was a gas station next door, and the people from the gas station are looking over, and they're in the convenience store, and they're all, you know, tell that guy to shut up, you know, and the guy just wouldn't stop. And he was cursing at the police officer and cursing at his wife and cursing at anybody who got in his way. He still hadn't lifted, you know, a hand to anyone, but he was threatening things. Even the threat wouldn't have mattered, but he was threatening things, and that didn't matter anyway. But that's disorderly conduct. That's because the people in the hotel, the people in the gas station, the people in the convenience store had it with this guy.
What was I going to say? We keep saying, you know, that the discon was facially insufficient. But in your brief, you actually said on maybe one or two occasions it was factually insufficient. I mean, it's basically the same thing, right?
Yeah.
Facts, facially facts.
Yeah, I mean, you're just playing semantics with it. Yeah, I think you can use those interchangeably.
Right. So it gets reversed, and William tries to get a lawyer to go into federal court on a civil rights case, and I can't get him one. And I help him go pro se. So he files a civil rights case in federal court, district court, against the town that employs the officers and the officers. And that's where the case is right now. It's actually, what happened is the district court judge, Joanna Siebert, dismissed the case. The town hired an outside firm. They moved to dismiss. The judge dismissed the case, claiming that he didn't have a favorable outcome. That wasn't, you know, having the appellate term dismissed all the charges wasn't a favorable outcome. She's wrong on what the reason for that. So he filed a notice of appeal, and now that case is up in the United States of America Court of Appeals for the Second Circuit. And the lawyer for the town and the officer is actually said, William Cuthbert doesn't have a case because he beat the charges on a jurisdictional technicality.
Okay, that's some of that I agree with, because that's the reason I didn't want to take that case, because that one's not a slam dunk. I still don't think it is. That one's a little bit tacky, because the appellate court in essence never got to the substance of this case. They didn't bother because they didn't need to go that far. So hold on a second. So that was my reservation, because I was afraid that the federal judge would say that. I was afraid that a federal judge would say, yeah, all right, you had this trial, then you had it reversed on appeal, but the reversal on appeal said that you should never have gone to trial in the first place, so we're not even going to address those issues. All we're doing is address the jurisdictional issue of the insufficient complaint in the first place. Okay, that's why the federal judge said that. Whether that's right or not, I don't know. I don't think it is, but that was a real possibility.
So,
I kind of thought that was going to happen.
What happened is that yes, the judge dismissed his whole case, alleging that he didn't have a favorable determination of the criminal.
Right. So the only way to cure that is when I was doing this thing for you, I had that decision to make whether or not I thought on any 3 points we were going to win. I really felt that, but I was playing it safe, so I threw every argument in. I threw in the
That
kitchen
bone
sink.
actually caught in William Cuthbert's throat.
Yeah, I mean, I threw the kitchen sink in because I wanted to make sure we won this thing. Had I left out the jurisdictional problem and just talked about the trial itself, and had it got reversed on that, and it would have, I think it would have, but I was afraid, what if it doesn't?
I know now that this thing is up on appeal, and William has to file a brief by July 30th. And he had a very incredible lawyer come forward to argue against the judge's motion to dismiss.
Right.
Fred Oberland, and he told us straight out, you're wrong.
Right.
Your test of what is a favorable outcome or determination, you're using the wrong test. So the issue here is a big issue.
It is, and it's a fine line there, and it's one that if a federal judge got confused by it, and their law clerks who were, talented lawyers, they fell for it too, which is what I thought would happen. I was a little worried about it too.
Well,
but I'm glad,
it's going to go. Here's the thing. What happened here is William Cuthbert was railroaded, no doubt. I mean, there was no reason to arrest him. There was no reason to prosecute him. There was no reason to take him to trial. There was no reason to convict him because he did nothing wrong. And then he wins on appeal. He wins for what? He's losing. So he goes down to the higher court, and they are trying to double down on all the damage that has been done to him. This guy has actually been railroaded to the state injustice system, criminal, and now with the feds, the same thing has happened. This is the little man saying, wait a minute, this is not supposed to happen in America.
Yeah. Appellate courts always look for the easy way out, and they did on this one too. Why did they have to put the effort in to go into the second half of the argument about the trial when they knew they could just dismiss it right away?
You think they did that on purpose?
I think that they saw that was legit, that was right, that it could be dismissed, so they don't bother ever talking about the rest of it because it really doesn't matter. As long as you got your reversal and the conviction is lifted like it never happened.
They had to realize that this, William Cuthbert, after the reversal, would probably sue in federal court.
Who knows what they knew?
And what they did was under the, actually, what they did, they really did the right thing. But the judge in the district court, federal, did something else. She didn't follow our state law.
I don't know. Well, who knows what happened there? Maybe that judge just didn't know it, or they always look for my experience on appeals is they will always look for the easy way out. If there's a jurisdictional issue where they can avoid getting into the substance of something, they always take it. I've seen so many cases where, well, the lawyer never objected to that, so it's not preserved for review. It's not reviewable on appeal. I've seen that so many times, and that's a common thing that they do. So I'm not surprised. It was a tactical decision to put all the arguments in anyway, and I just wanted to make sure we won the thing.
So in the federal district court, William was on his own. He was pro se, and he was granted informal purpose status. In other words, he didn't have to pay anything for filing the fees or transcripts. But along the way, this really incredible lawyer came on board pro bono, only to argue that the judge was wrong in dismissing his case, and he did that. And it was a great argument. And he said to me, I don't think she'll read it. And I don't think she did. She just doubled down on what she said. Mm. And he was saying to her, something, you're supposed to follow the state law, our state, the Court of Appeals. You're not doing that. You're using the wrong standard. But they didn't care. So they never thought that he would file a notice of appeal, I don't think. In fact, she tried to discourage him by saying, and Oberlander said, this is very unusual. She actually said in her decision, any appeal would not be in good faith. I never, and she revoked his informal purpose status. Well, even Oberlander was surprised that he went ahead and filed a notice of appeal. He's not going away. Yeah. So He's going to have his day in court, and he can't argue. So I have to get someone. I'm not asking you, but someone to stand in there. If I had not been forced to retire, I would seriously think, asking the court to admit me just for the argument. It's such a great argument. I mean, a great argument. Anyhow.
Well, you're right. If you can get them to listen to you.
They'll listen to me. If I'm in that
No, I mean,
courtroom,
for them to even buy into the argument in the first place, they have to grant you the right to appeal. I mean, if it's not, they consider it, this district court judge and federal court considered it not even an appeal that would be taken in good faith. Well,
it's
and you're going to take it anyway.
Yes.
So that's the first threshold you have to get over.
You told me just recently, even if the court denies his motion to vacate that portion of the sentence of the decision, saying it would not be in good faith, he should still go forward.
That's the problem you have right now.
We haven't got a decision on that yet.
Right.
But I'm thinking
if you do, then you've got something to work with. But right now, that's what I was afraid of. I was afraid that the federal would do exactly what I thought.
I would not. I mean, if I was his lawyer, I would say, we're going forward. They're not shutting us down. Not here. Not in America.
You got to see what the Court of Appeals is going to say. I mean, the United States Court of Appeals.
Old time. Where have my old friends gone?